Good morning, good afternoon, everyone. My name is Nicole Savia. I am the permanent representative of the International Association of Democratic Lawyers to the United Nations here in Geneva. I'm honored to welcome you to this virtual side event at the 48th session of the Human Rights Council entitled Ensuring Accountability for the Displacement of Palestinian Bedouins, the Role of the Human Rights Council. This event has been organized by IADL in partnership with a joint project implemented by Quds University Belfast, Quds University, Community Action Centre and Human Rights Clinic, Liverpool John Moores University and Trinity College Dublin. The Bedouin Arabs have inhabited southern Palestine as far back as the 7th century. In 1948, between 65,000 and 100,000 Bedouins were estimated to live in the Negev area. Like the rest of the Palestinian communities, the Bedouin Arabs of southern Palestine experienced social collapse and physical destruction of their space because of the Nakba. During this time, approximately 85% fled or were expelled from their land. It is estimated that only 13,000 Bedouins remain within what became the State of Israel, many of whom were later internally displaced, subject to forced urbanization projects, informal housing conditions, and all kinds of discrimination. Those who were expelled became refugees in the Gaza Strip, Egypt, Jordan, and the West Bank, where they are living in precarious humanitarian conditions. These communities, whose traditional livelihood has always been agriculture and herding, are extremely vulnerable, both because the Israeli military has seized large swaths of their land and because they have limited access to vital infrastructures and services such as water, electricity, sanitation, health, education, transportation, etc. As we will see, the Palestinian Bedouin communities in the so-called EU1 area in the Jerusalem periphery are among the most vulnerable in Palestine. Bedouin communities in Palestine are continuously at risk of forced displacement and transfer at the hands of the Israeli authorities through direct and indirect means. Direct means include the outlawing of communities through an highly discriminatory planning regime imposed across large swaths of the West Bank and the related destruction of housing and other property, and severe limitation to their freedom of movement and the right to work through an inequitable permit system. Indirect means include the creation of a coercive environment that includes a continuous threat of demolition and evictions, seizure of vital infrastructure, and the continuous denial of basic human rights, limiting the development prospect and exacerbating the humanitarian vulnerabilities of these communities. The risk of forcible displacement is intrinsically tied to Israel expansionist and annexationist policies in the West Bank and Jerusalem, which drives the displacement of Palestinians in areas earmarked for settlement expansion. The policies of forcible displacement and settlement expansion not only lead to multiple human rights violations, but may also amount to international crimes. At this regard, the accession of the State of Palestine to the Rome Statute of the International Criminal Court in January 2015 is particularly relevant, as it opens up opportunities for accountability for alleged crime perpetrated against Palestinian Bedouin communities. I will now pass the floor to Alice Panepinto, Senior Lecturer in Law at the Queen's University Belfast. Alice is leading a joint project run by different academic institutions that seek to better understand the humanitarian impact of continued forcible transfer of Palestinian Bedouins communities living in the so-called EU1 area in Jerusalem, and how impunity for violation of international law contribute to the deterioration of humanitarian vulnerabilities. Welcome, Alice. Please, you have the floor.
Thank you very much, Nicole, and a big thank you to all the team at the International Association of Democratic Lawyers for organising the event today. It's a great pleasure and honour to be here with you. I am going to share my screen. So hopefully you will be able to see my slides in just a moment. If you can confirm that you can see my slides.
Yes, yes, we can. Perfect.
Perfect. So today we'll be talking about ensuring accountability for the displacement of Palestinian Bedouin communities in the Greater Jerusalem area, an area referred to commonly as E1. And we're here today to consider what the role of the UN Human Rights Council might be in this regard. So, as all academics, we have research questions, and our research question is, what is the cost of impunity for serious violations of international law in this community? So our project, which is funded by the Arts and Humanities Research Council and the Foreign Common and Development Office, analyses the impact of protracted impunity for repeated violations of international humanitarian law and international human rights law in the Palestinian Bedouin communities at risk of forced displacement. It's very difficult to summarize a project which is so complex and articulate in just a few minutes. Unfortunately, my colleague and driver of the project in Jerusalem, Dr. Munir Nuseibah, will follow in just a few minutes. So what I thought I would do was to offer some themes that emerge in how we are trying to answer this research question. What is the cost of impunity for serious violations of international law in the Bedouin communities in E1? First of all, homes are demolished and homes continue to be demolished. And here is a selection of images from one of the recent demolitions in a Palestinian Bedouin village in the central West Bank. Schools are demolished. We know about the very high profile example of the demolition orders on the village school in Al-Khan al-Ahmar, but there are many other examples of schools and other public buildings in Bedouin communities in Palestine which are targeted for demolition. And here is another picture that illustrates where the children go to learn once their schools are demolished. Thinking more broadly, of course, it's not just about homes, not just about schools, two of the most important and fundamental places for community survival. But more broadly and more fundamentally, the humanitarian vulnerabilities are exacerbated when there is no accountability for repeated violations of IHL and human rights. Human rights are denied, and the full package of human rights is denied. So we have the most obvious when we see these images, human rights that come to mind. So the economic, the social, the cultural rights, but even the civil and political rights are totally denied in this sort of context, where there is protracted impunity for international law violations in the Bedouin communities. What about development? Well, it goes without saying that in this context, where homes are demolished, opportunities for education are curtailed, and the humanitarian vulnerabilities exacerbate year by year, month by month, the opportunities for long-term sustainable development are practically non-existent. And of course, we need to reflect upon what Mikol already mentioned, the coercive environment in which the Palestinian Bedouin lives become harsher. And that is one of the fundamental reasons for displacement. So it's not just the direct displacement which has occurred when Bedouin families see their homes demolished and they are physically dragged from their homes to other locations, but that slow violence in which every day is uncertain. You never know whether tomorrow morning at the early hours you might receive a knock at your door or somebody shouting in a foreign language outside your bedroom. This is the sort of environment whereby it's not just the direct lifting of families and transferring them to other locations, but it's also the day-to-day uncertainty that drives displacement. And this is something that is really emerging in our research so far. So it's something that I invite everyone to reflect upon. And of course, there is the bigger picture. And Mikol already mentioned some of the drivers of the bigger picture here. And to these, I would add that what happens if there is a lack of accountability for international law violations occurring in Palestinian Bedouin communities, these things that I've just listed contribute and are contributing to emptying parts of Palestine from its Palestinian inhabitants. And of course, this rings alarm bells for international lawyers and anyone working within the human rights community. If we want to zoom out and look at the bigger picture more holistically, of course, we must link what is happening in the Palestinian Bedouin communities to the right to self-determination of these Bedouin communities as Palestinians alongside the rest of the Palestinian people. And of course, the long-standing question of the right of return. So these communities live in these precarious conditions because, as Mikol already mentioned in her introduction, they were originally displaced in the late 40s from their ancestral lands in what is now the Negev. So I think my time is nearly up. So I will leave you with a set of questions. Again, this is our job as academics, and thank you for bearing with us, to reflect on in the context of the UNHRC meetings at this particular point in our calendar year. So how does the threat of forced displacement, the context of coercive environment and discriminatory policies against Palestinians in and around Jerusalem affect the human rights of Palestinian Bedouin communities? These are big questions, but they are urgent and require very concrete answers that relate back to ensuring accountability for international law violations. How does the continuous risk of home demolitions in Palestinian Bedouin communities, as well as the actual destruction of residential structures, including everything that comes with that, so water tanks, solar panels, electricity pylons, affect the right to adequate housing for Bedouin communities in the occupied Palestinian territory? And if we want to return to the theme of international accountability for violations of international law, why are international accountability mechanisms crucial for combating impunity for international law violations committed against Palestinian Bedouin communities? This is not something that can be dealt with locally in any court in Jerusalem, where there are questions of international law violations. There is always a question of international accountability for those violations, where accountability is not occurring locally in any way. And I will leave you with a final question. Many of us in the Academy were very interested in the development earlier this year of the new Commission of Inquiry. So our question would be to think about how the new Commission of Inquiry established earlier this year by the Council will contribute to ensuring accountability for human rights abuses suffered by Palestinian Bedouin communities at risk of forced displacement. So I'll thank you very much for listening so far, and I'll hand over to our esteemed panelists. Thank you.
Thank you very much, Alice, for presenting us this important initiative. It's really important to have the academia engaged on in these kind of discussions. And thank you very much also for underlining the serious and dramatic consequences of protracted impunity. And also for the important question you asked, for asking answer to the important question you have formulated. Thank you very much for your intervention, Alice. Let's now turn to our next speaker, Munir Nuseibah. Munir is a human rights lawyer and an academic based in Quds University in Jerusalem, Palestine. He is the director and co-founder of Quds Human Rights Clinic, the first accredited clinical legal education program in the Arab world, and the director of the Community Action Center in Jerusalem. Good afternoon, Munir. Many thanks for accepting our invitation. Please, you have the floor.
Thank you very much, Nicole, and many thanks also to Alice. It's really a great honor to be speaking in your panel and also speaking in the same panel with distinguished panelists who are talking today. So thank you all very much, and thanks to everybody who have attended this this side event. So let me share my my PowerPoint as well. My presentation will be basically a background and a factual background about the Bedouin communities in the southeastern periphery of Jerusalem, most importantly, the E1 area that was mentioned by Nicole and Alice. So let me start by giving a quick background about displacement. Since 1948, the year in which the United Kingdom decided to end its mandate, the United Kingdom decided to end its mandate in Palestine, Israel has been continuously colonizing, dispossessing, and displacing Palestinians. During the event known as Nakba in 1948, the event, 80% of the Palestinian population that lived in the areas that became Israel during the Nakba were displaced from their homes. As mentioned by Alice before, as well as Nicole, the overwhelming majority also of the Bedouin communities in Al-Naqab, the desert in the south of mandatory Palestine, current day Israel, were also displaced during that period. During that period, Israel was established on 78% of Palestine, and this is the map that shows this area. Afterwards, in 1967, Israel occupied the West Bank, including East Jerusalem and the Gaza Strip. And since then, it started a new colonization program that targeted the West Bank and aimed at increasing Jewish inhabitants, settlers in the West Bank and Gaza Strip as well in the past, and decreasing the Palestinian population. The Bedouin communities are not a unique community when it comes to displacement. They are only another community with specific features that are continuously displaced. However, targeting them comes into, comes as a special, in a special way because of the way they live. Bedouin communities are not urban communities. They are different if you compare them to the villages and the village communities, the farmers, the peasants, historically who live in villages but in concrete houses, are always busy with agriculture. But the Bedouin communities live in areas that are outside the built space. In many cases, they did not historically necessarily live in villages, although that's not totally true. Some of them have lived in villages that are built up, but they were either nomadic or semi-nomadic, living between different areas according to the season. They live on grazing their animals, and so they have a different type of lifestyle. This probably has made them more vulnerable to the colonizing power. they were displaced, as we mentioned earlier, heavily in 1948 and afterwards. And then once Israel came to the West Bank, they continued to displace them, to demolish their houses, to consider their presence illegal. And it's important to say, although it's outside the scope of this panel, that the displacement of the Bedouins is not only happening actually in the occupied West Bank, it's actually still happening until the current day in the Naqab Desert, in the area that has become Israel. There are dozens of villages that Israel considered unrecognized villages. Basically, Israel continues demolishing these villages, displacing the inhabitants from there, trying to concentrate them in townships and close to where they used to live in order to empty the land more and more and open it for more colonization projects. A similar pattern is happening with different tools in the West Bank. We are focusing here on the E1 area in which the Jahalin tribe live. There are 2,300 Bedouins living in that area who were expelled from their village, which is known as Tel Arab in the 1950s. This village is actually in the Naqab, in what is today Israel. So these people are refugees displaced from their original homes in what became Israel in 1948. Then, since 1967, the occupation, Israel has been continuing to expel them and move them. The more it expands its illegally built settlements, which are considered war crimes in international law, the more it continues to displace them from where they live to other places. The picture here shows two communities. It shows the fancy settlement in the back of Ma'ale Adumim, and it shows a Palestinian Bedouin community that is living in a very basic structure that is also threatened with demolition. This picture is a representative image of the way that the Palestinian Bedouins in the West Bank live. The area of E1 is an area that Israel plans in order to link the occupied East Jerusalem, which was illegally annexed by Israel, as it can be, as it is shown here in the map. The purple line is the line of the illegally annexed East Jerusalem. And the E1 plan, which is also clear here in the map, will link this town, this city, this East Jerusalem, and the Jewish settlements in East Jerusalem with the settlement in the middle of the West Bank known as Ma'ale Adumim, one of the biggest settlements in the West Bank that inhabits in which more than 40,000 settlers live. This settlement, the E1 plan promises to increase and add additional 15,000 housing units on 12 kilometers square, and that will certainly add to the whole population of settlers, again, a war crime in international law, in the West Bank. It is important here to mention that in the West Bank, the population of settlers has increased until 2018 to 671,000 inhabitants. And this increase is creating facts on the ground that are very difficult to reverse. They are moving families and lives into the West Bank, making it very difficult to reverse and to actually accomplish a real peace agreement by the end of the process. As you can also see in this map, this is Donald Trump's plan for peace as he suggested it in 2018. And you can see how the imagined Palestinian state that Donald Trump suggested it takes into consideration all of these settlement areas and basically creates a Palestinian state that is certainly not connected geographically and not connected to any neighbor, certainly Jordan. And obviously that's an important reason why the Palestinian leadership thought that this is not something that's going, that it was willing to accept. In this Google Map picture, I am showing how one of the communities called Wadi Abu Hindi, which I'm pointing to here in this map, it's between two different Israeli well-developed settlements. And this will show us also why Israel believes that this community should not exist here. For them, this area should be open for expanding Jewish-only settlements. And therefore, these Bedouins should not live in this area. Where should they live? From the point of view of the Israeli military government, these people should be concentrated with the rest of the Palestinian populated areas. So they should actually go and live in villages and towns where already a majority of Palestinians live. So they want to empty the land in order to make it easier to expand these settlements. This is the community that they find as a threat. This is the same community, just a picture from the ground. And this is a picture that shows the only water source that this village enjoys. And I'm using brackets while saying enjoys. And this is, of course, not authorized by Israel. This is a water hose that was extended from the nearby village, Sawahri. And that's the only water source for the whole village. One of the problems is that these villages and towns are unable to enjoy the most basic things in their lives, including water, and most importantly, water. As Alice mentioned before, the issue is that there is repeated house demolitions. The house demolitions are because the Palestinian communities in the E1 area, but also all the Bedouin communities in the West Bank are not allowed to build because the zoning and planning plans of the Israeli army government in the West Bank only encourages Jewish settlements. There are also NGOs like one called Regavim, which watches Palestinian construction in these areas and continues to encourage the Israeli military government to demolish these houses continuously. So the houses are demolished, the people are evicted, but also other properties are destroyed and confiscated, including animals, including solar panels, and a very important limiting is limiting the space for grazing the animals for the Bedouins in these areas is a problem that is limiting the ability of these Bedouin communities to make a living, even a very simple living. This is all because of the discriminatory planning and permit regime that Israel has established in the area. But over that, there is the issue of settler violence. The settlers who live around these communities contribute a lot with violence that happen frequently, that scare the families, and in many cases push them out of the area for their own safety. Of course, the Palestinian communities are trying to continue to live, are trying to be resilient, they are trying to rebuild. They get sometimes assistance from the international community. For example, the European Union and many countries have supported the communities through solar panels, through houses, etc. However, unfortunately, this financial and material support is not coupled with the political support that would be in the way that these countries would pressure Israel sufficiently to get them to stop these continuous violations. Unfortunately, international law has not been very helpful until the current day. Yes, we know what international law says. We know these actions are war crimes. It's very easy to make that analysis. However, the international community has been thus far only saying words. Of course, I know that I'm addressing the Human Rights Council and what I expect from you, but of course, I expect more than words. We expect real action. I'm sure my colleague Tristino will talk about what is expected from the international community, but I'm also showing you this cartoon which I picked up from a newspaper a few years ago, actually, showing how the Palestinians are trying to use the UN and international law in order to survive. But as you can see, it seems very loose and it's not helping enough. I think Palestinians, currently, Palestinians are only looking for international law in order to get protection. Unfortunately, this is not happening. There is a new shift now. The International Criminal Court has decided finally that it has jurisdiction over Palestine, and it said that the territory includes the West Bank, including East Jerusalem and Gaza Strip. I think this is very promising and very important. In fact, Al-Khan al-Ahmar community was due for demolition after an Israeli Supreme Court decision allowing this demolition. But after the former prosecutor of the ICC published a statement saying that it is concerned that this demolition might amount to a war crime, since then the demolition has not happened. This has shown evident protection, of course temporary, however, it's still protection. I think it's very significant. And I think if the ICC continues to take its work and its job seriously in Palestine, this might be an important game changer. Thank you very much. And I'll be happy to answer questions if there are any at the end. Thank you.
Thank you very much, Munir, for your very interesting and comprehensive presentation and for all the valuable work you are doing on the ground. Hope there will be soon another occasion to work together. As we have mentioned, Bedouins are one of the most vulnerable communities in Palestine. The illegal actions of the Israeli authorities lead to numerous violations of their fundamental rights. And in fact, Bedouins communities are specifically mentioned in several Human Rights Council resolutions. Moreover, their situation is closely monitored and analyzed by several UN treaty bodies and UN special procedures mandate holders. Today, we have the pleasure of counting with the participation of 2 UN Special Rapporteurs who has been very active on this important issue. Professor Michael Lynk, Special Rapporteur on the human rights situation in the occupied Palestinian territories, and Professor Balakrishnan Rajagopal, Special Rapporteur on the right to adequate housing. Professor Lynk is very well known by all people working on Palestine in Geneva and elsewhere. He has a long academic career and also a vast working experience in the field. Since he was appointed Special Rapporteur in 2016, despite the systematic lack of cooperation by Israel and the enormous pressure existing on its mandate, he has been tirelessly documenting and reporting about all human rights violations committed in the OPT, including against Bedouins, urging the international community to assume its legal responsibility to countering this violation in accordance with all relevant provisions of international law. Good morning, Professor Lynk. Thank you very much for being with us. Please, you have the floor.
Nicole, thank you very much for that introduction, and thank you for the invitation to speak today to the side event on the current session of the UN Human Rights Council. It's a pleasure to be asked and to be alongside so many expert panelists. The situation of the Palestinian Bedouin communities in the occupied West Bank is a classic example of the ravages and the injustice of this perpetual occupation. While there are two Bedouin communities, Hain al-Lamar, as Munir has mentioned, which is near Jerusalem, and Hamsa al-Baqa in the northern Jordan Valley, that have caught extensive media, civil society, and diplomatic attention over the past several years because of the extensive efforts by Israel to demolish and relocate these communities. There are many other Bedouin communities in the OPT that are facing dire threats to their homes, their livestock, and their livelihoods. In the short time that I have today, let me focus on the situation of Hamsa al-Baqa. On the 7th of July, the Israeli civil administration, the arm of the Israeli Defense Forces, which administers the occupation of the West Bank, accompanied by military troops, demolished 27 residential shelters, animal structures, and water tanks, and confiscated the community's belongings. According to reports at the time, 11 households comprising around 70 people, including 35 children, were displaced. Among the sequestered possessions were food, water, and clothing, leaving the community without shelter or substance in the summer heat of the Jordan Valley. This is a classic example of forced displacement. As I said at the time, this demolition is both illegal and heartless. As the occupying power, Israel is strictly forbidden from destroying Palestinian property unless it is absolutely required by military necessity during active armed operations. The forced transfer of the inhabitants of Hamsa is also strictly prohibited as a grave breach and a potential war crime under the Fourth Geneva Convention. Hamsa al-Baqa is one of the number of Palestinian herding communities in the Jordan Valley. These communities are exceptionally vulnerable, both because they have limited access to water, sanitation, education, and electrical power, and because the Israeli military has seized large parts of their traditional lands for military firing zones. In contrast, the illegal Israeli settlements in the Jordan Valley are left undisturbed by the military. This progressive seizure of Palestinian lands, together with the protection of the settlements, is a further consolidation of Israel's de facto annexation of the West Bank. In my recent reports to the UN General Assembly, I have called attention to the large gap between international law and international accountability, between promise and performance, between tolerating an endless occupation and taking decisive steps to bring it to a complete end. Accountability, I have said, must rise to the top of the international agenda regarding Israel's occupation. Our search for justice in this occupation must truly focus on the international community. It has the power, if it chooses to act with conviction and unity, to end the occupation through meaningful accountability measures, and it must match its criticisms with consequences for Israel, as Palestinians and many Israelis of conscience have called for. How to hold Israel accountable? Civil society and the international community has to adopt a plan of action that includes the following. First, fully support the work of the Office of the Prosecutor of the International Criminal Court as it investigates whether the Israeli settlements violate the Rome Statute. Supporting the work of the ICC is not a choice for member states. It's an obligation. Second, call upon Israel to fully dismantle its settlements, as repeatedly stated in UN resolutions at the Security Council, the General Assembly, and the Human Rights Council. Third, adopt a comprehensive menu of accountability measures to bring Israel into compliance with international law should it continue to defy the international community. The International Committee of the Red Cross, as one shining example, has developed a lengthy list of accountability measures that are compliant with international law and practice and have been employed with some success in other situations involving grave abuses of humanitarian law and human rights law. Fourth, ensure full accountability of Israeli political, military, and administrative leaders who are responsible for the grave breaches of international law in the occupied Palestinian territory. Fifth, call upon all UN member states to implement the call of UN Security Council Resolution 465, adopted in 1980, not to provide Israel with any assistance to be used in connection with the settlements. And 6, support the growing initiatives to support an advisory opinion from the International Court of Justice in The Hague to determine whether the 54-year-old prolonged occupation of Palestine has crossed the threshold into illegality. The time for criticism of Israel has passed. The time for meaningful accountability measures has arrived. Criticism without consequences is empty, because this occupation will not die of old age. Former UN Secretary General Ban Ki-moon wrote in a Syrian article published in late June of this year by the Financial Times that it is the lack of any international legal accountability that has enabled Israel to ignore successive UN resolutions. A new approach grounded in international law and a rights-based approach is the only path forward for a just end to this perpetual occupation. Thanks very much.
Thank you very much, Professor Lynk, for your important contribution to this panel and for all the concrete recommendations you made, and in general for the hard work you are doing. As you know, you have all our appreciation and support. Our next speaker is Professor Balakrishnan Rajagopal, UN Special Rapporteur on Adequate Housing as a component of the right to an adequate standard of living and on the right to non-discrimination in this context. Professor Rajagopal assumed his function as Special Rapporteur in May 2020, in the middle of the COVID pandemic. He's Professor of Law and Development at the Department of Urban Studies and Planning at the Massachusetts Institute of Technology, a lawyer by training and a human rights expert. Although he has only recently assumed his function, Professor Rajagopal has already sent at least 2 communications, as far as I know, to the government of Israel regarding Bedouin situation. Good afternoon, Professor. Thank you very much for accepting our invitation. Please, you have the floor.
Thank you. Thank you very much. Let me start by thanking you and the organizers for this very interesting event. I'm here mostly to listen and learn in this event. I, of course, fully agree to start with by recognizing and agreeing with others that the displacement of the Palestinian Bedouins is a tragic test case for international law and global justice. The Bedouins are ethnically cleansed and segregated, and that is a fact that has been well documented both by historians and scholars, as well as, of course, by the experience of people who are living on the ground. The question that some scholars have asked, for example, Professor Oren Yiftachel has asked, is Israel an ethnocratic state? In his recent co-authored book with Ahmed Amara and Sandy Kedar, Emptied Lands. As part of a larger story of dispossession and colonization, there is a need to look at the historical experience of Bedouins. To me, what has actually been interesting looking at the experience of Bedouins is the use of private property law to deny the rights of Bedouins, and then solidify the denial of rights by the use of constitutional and international law. To me, it appears to be very similar to the record in other settler societies, such as the United States, towards indigenous people, which led to annexation and ethnic cleansing and immense suffering. For example, in the case Johnson versus McIntosh in the United States, there is a similar use of private property law as well as constitutional and international law. Now, the problem would not become serious if the domestic legal system in Israel had responded with a modicum of justice to the claims brought by the Bedouins. However, the decision of the Israeli Supreme Court in many cases, including, for example, the 2018 case of Khan al-Amar, authorized and justified the Israeli government's demolition of what has been called unrecognized Palestinian villages. That ruling has now set a precedent that critics have claimed would allow Israeli government to, quote, ethnically cleanse any Palestinian village within its territory, despite the fact that the practice is considered illegal under international law. The critics have unfortunately been proved right again and again, as we have seen waves of home demolitions, displacement, and ethnic cleansing. The reasons, of course, for the ethnic cleansing and displacement range across many different factors, both big and small. They range from factors such as Judaization to the needs of capitalist expansion, a form of racial capitalism, as the scholar Cedric Robinson named it. The sharply widening inequality between Jews and Palestinians, and especially Bedouins, for example, in per capita GDP, to take only one measure, is a constant reminder that the expulsion and dispossession are part and parcel of a larger project of racial capitalism, not just a primordial struggle for historical rights. In the face of the failure of the domestic legal system in Israel to ensure the protection of the rights of Bedouins, international law has, of course, loomed large as a fallback mechanism for the vindication of rights. Although international law, of course, is complicit in the denial of rights to indigenous people, including the Bedouins, such as, for example, in the use of the terra nullius doctrine, and in the face of what Munir Ahmed before me called the failure of international law, of which there are multiple. Human rights and humanitarian law mechanisms are nevertheless terrains for the struggle to recognize the rights of Bedouins with all their limits. Now, as far as my mandate is concerned, it is, of course, very focused on this issue because of the centrality of discrimination to the mandate itself. The word discrimination, after all, is in the very title of the mandate. It's housing in the context of non-discrimination. And also, as I have made it clear recently, there is a need to focus again on the increasing patterns of discrimination and spatial segregation that we see around the world. And the Israeli case, particularly involving the cleansing, ethnic cleansing of the Bedouins, and the attempt to concentrate them in particular regions, is a classic test case of segregation. I have also joined or initiated letters, as was noted, both about forced removals, displacement, home demolitions, but also about the denial of services like water and sanitation, which accompanies the status of Bedouins as quote unquote unrecognized. The UN communications procedure has seen so far 11 letters on the Bedouins issue with the state of Israel. Of course, there are uses of this mechanism in terms of the ability to shed light and to allow moments when mobilization can occur on the ground around the need to bring many of these issues to light. But at the same time, as has been noted, there are severe limits to this mechanism as well, including the inability of the human rights system to be able to ensure accountability, especially in the face of persistent failure by states to respond to legitimate concerns for violations of international law. Now, so what else is possible for accountability? The recently established OPT Commission indeed promises to be yet another arena where the struggle for accountability can be continued. Are there perhaps options under domestic law or policy that are underexplored? I was interested to see that Munir also noted counter-planning, like progressive master plans, which contradict Israeli official plans, which seek to displace the unrecognized villages as one possible option for mobilization. International criminal law, of course, has remained a distant possibility all these years, although, as was noted, there are some recent signs of movement, including on charges that I hope would include the historic crime of apartheid. On the whole, I want to conclude by noting that the Bedouin land grab case in Israel presents a test case for international law, and I hope that it meets this challenge effectively, including by taking on the suggestions made by my respected colleague, Michael Lynk here. Thank you very much.
Thank you. Thank you very much for your intervention and for being with us today, for your inspiring remarks. At the end of the meeting, if we have time, we will have some questions, but we still have our last but not least speaker, which is Triestino Mariniello, Senior Lecturer in Law at the Liverpool John Moore University and member of the legal team representing Gaza victims before the ICC. He will be delivering some concluding remarks. Welcome, Triestino. Please, you have the floor.
And thank you very much, Nicole. Thank you, everyone, for accepting our invitation to join this side event today. I will try to provide some concluding remarks in light of what our speakers have said today. In particular, I think what arises from the entire discussion today when it comes to the Israeli policies against Bedouin communities in Palestine is a clear state responsibility for serious violation of international humanitarian law, international human rights law, but also has clear highlighted by the three speakers and also by Alice at the beginning, also individual criminal responsibility for the alleged commission of core crimes falling within the ICC jurisdiction. I would like to focus in particular now on this individual criminal responsibility in light of what Munir said at the beginning, the fact that there is an ongoing investigation and the ICC could be at the moment, well, constitutes at the moment the only form of international criminal justice available to the victims of these crimes. It has already been said that the prosecutor has opened an investigation into this situation and that the trial chamber has confirmed that the prosecutor requests that Palestine is a state under the Rome Statute, and as Munir said, the territorial jurisdiction in this situation covers the West Bank, including East Jerusalem and the Gaza Strip. So it also covers the alleged crimes we are talking about today. So this investigation covers alleged war crimes at the moment committed by both Israeli authorities and the Palestinian armed groups. Has discussed today the displacement of the Bedouins, particular in the E1 area, is intrinsically connected to settlement expansion. And the Bedouin communities, indeed, that are most at risk, as we have seen, of forcible displacement, are indeed those closest to the settlements. And according to the prosecutor of the ICC, there is a reasonable basis to believe that members of the Israeli authorities have committed the war crime of transferring directly or indirectly by the occupying power of parts of its own civilian population the territory it occupies, according to Article 8 of the Rome Statute, and the deportation or transfer of all of parts of the population of the occupied territory within or outside this territory. So, if we discuss about accountability as we are doing today, as we have seen, there are not only grounds to say that the facts discussed amount, as I said, to serious violation of international human rights law, international humanitarian law, but also to alleged international crimes. In particular, when I say international crimes, I mean war crimes and crimes against humanity. The same prosecutor, Bensouda, as Munir reminded us, with respect to the demolition of the Bedouin village of Khan al-Khmar in the West Bank, stated that the extensive destruction, and I quote her words, of property without military necessity and population transfers in an occupied territory constitute war crimes. Professor Lynk also placed emphasis on this alleged war crime under the Rome Statute that established, of course, the ICC. So, as we have just said, the first war crime related to settlements construction is already falling within the scope of the ICC investigation. But I think that there is, on the basis of what we have heard today, there is not only evidence that the case concerning the the settlements is currently being committed or has been committed against Bedouin communities, but that it would also be admissible before the ICC, as according to Israel, all authorized settlements are entirely legal. So there has not been, and there will not be any domestic investigation of prosecution in relation to this crime. But the same applies also to destruction of civilian structures of Bedouin in the West Bank. In light of the facts we have explored today, the ICC investigation into the Palestinian situation is a welcome decision, particularly into war crime related to settlements, as I said. However, the scope of this investigation is still very narrow because it excludes a number of crimes we have seen today that have been or are currently being committed against Bedouin communities in the West Bank, including East Jerusalem. For instance, if we look at some of the most recent data, we can see how, if we are discussing of facts falling within the jurisdiction of the ICC, so put in place after 2014, there have been destruction of 278 residential structures belonging to Bedouin communities, 101 agricultural structures, and more than 1,000 individuals, actually 1,087 Bedouins have been forcibly transferred by Israeli authorities. We have also seen that there are pending destruction orders against primary school, at least primary school in different Bedouin communities. In Abu Nawar, Al-Muntar, Wadi Abu Hindi, Khan al-Khmar, and Al-Muharrajat. There are pending demolition orders. So there is not only enough evidence in light of this, that the war crime of transferring civilian population that we've seen before is being committed or has been committed, but also the war crime of extensive destruction and appropriation of property not justified, as Professor Lynk said before, by any military necessity and carried out unlawfully and wantonly has been committed against these communities. When we talk about this crime under Article 8, we include, well, according to the jurisprudence of international criminal tribunals, also properties, this includes also, personal property in occupied territories whose destruction was not necessary for any military operation. So all the different properties protected by the Geneva Conventions. But I think there is also a reasonable basis, on the basis of the different reports related to the Bedouin communities in the West Bank, including East Jerusalem, to argue that the war crime of outrage upon personal dignity, in particular humiliation and degrading treatment against Bedouin communities, have been put in place by members of the Israeli authorities. Just to be clear, this provision criminalize committing outrage upon personal dignity, and it's allegedly committed in relation to the humiliation, degradation, or other violation put in place against the dignity of Bedouin communities in Palestine. But in addition to war crimes, I think it's also important to mention that this conduct, these acts we have heard today, also may amount to crimes against humanity, which is the definition of crimes. Well, the crimes against humanity themselves are the great absent at the moment in the investigation of the prosecutor. In particular, when I say crimes against humanity, I refer to the forcible transfer of the Syrian population, the forcible displacement of persons, of course, by coercive acts from the area in which they are lawfully present, the persecution, and as Professor Rajagopal was mentioning before, also of the crime of apartheid, which is one of the underlying offenses of crimes against humanity, as we know under Article 7 of the Rome Statute. It's important to introduce crimes against humanity in this discussion, not because I personally believe that they are more serious than war crimes, but because talking about war crimes gives the idea, places the emphasis, in other words, on the context in which these different acts we have seen today are allegedly committed, in the context in which these acts against Bedouin communities are committed. And the context is, of course, in general, the longest military occupation of modern times, but the context which has been described today indicates a widespread, a systematic attack against civilians, in this case against Bedouin communities. And the context, as we know, in international criminal law is extremely important because it determines the crime, and in particular the crimes against humanity in these specific circumstances. When I say that there is an ongoing widespread and systematic attack against Bedouin communities, I refer in particular to the settlement. Without any intent to be exhaustive for a matter of time, I'm going to conclude. I refer to the longest, I refer to the settlements constructions, the transfer of the Israeli population in the occupied territory, the creation of two distinct legal regimes in the West Bank, one for the settlers and one for Palestinians, the disproportionate use of force by the Israeli security forces against Palestinians in the West Bank, coupled, as Munir was saying before, with the failure of Israel as occupying power to protect Palestinians from the violence of Israeli settlers, in addition to the use of excessive lethal force by Israeli security forces against Bedouin communities in the context of law enforcement operation or civilian demonstration, and incidents of collective punishment and of ethnic cleansing, as Professor Rajagopal brilliantly emphasized. So to conclude, this time I really conclude, if we talk about accountability, the ICC, as it stems from today's discussion, I think remains at the moment the only mechanism of international criminal justice that remains available to the victims of the alleged crimes we have seen before. And for this reason, it's extremely important that the Human Rights Council, as Professor Lynk was saying before, and the international community was referring more in general, but I say in particular the Human Rights Council and UN Commission of Inquiry continue to place emphasis on the role of the International Criminal Court in this situation and support the work of this institution and provide the same institution with full cooperation, invite its member states to cooperate with the court and invite in light of what we have seen before, the Office of the Prosecutor to expand the scope of the investigation also to the further alleged crimes committed against the Bedouin communities, as briefly discussed today. Many thanks again to everyone for taking part in this webinar, and we look forward to any comments or questions. Thank you.
Thank you very much, Triestino, for the important work you are doing before the ICC. You have all our support. Indeed, the opening of the investigation by the ICC represents a big source of hope for all of us. Regarding, indeed, it would be very important to have the Council, the Human Rights Council, supporting the work the ICC is doing. And also, I think it would be important for the Council to transmit all the evidence it has been collecting through its mechanism during all the last years, transmit all the evidence collected to the office of the prosecutor, because I think some, for example, the Goldstone report already asked, they recommend the High Commissioner to transmit this evidence. I don't know if this was done, but I think it would be important because the Human Rights Council, is true that is not very good in holding Israel accountable for its crime, but has been collected a huge amount of evidences during all these years. Thank you, Triestino. As I said, you have all our support. Now we still have some time for a short debate. If someone has questions or remarks, please, you can type it in the chat or in the Q&A feature, and I will turn it to the panelists. I saw that there are already some questions, but you can see it, but I read it out for you. Netta Marshit, she's asking if we could relate to the applicability of indigenous rights and the UN Declaration on the Right of Indigenous People and the special protection it may grant to Palestinian Bedouin. If someone wants to speak on this.
Let me just say a few words with respect to this, Nicole.
Thank you.
I really appreciate the question with respect to UNDRIP, the UN Declaration on the Rights of Indigenous Peoples. It is a debate that's going on now in my home country of Canada. We have actually passed the UN Declaration into law, into Canadian law, at the federal level, and also at one of our provincial provinces as well. And the key point that has been part of this debate over the last several years in Canada is a stipulation that in UNDRIP that there can be nothing without us, that there can be no development, no resource planning, no land changes, nothing that affects us as Indigenous people, goes the argument of Canada's Indigenous population and leadership, without us being consulted and involved and treated, in fact, on a nation-to-nation basis. Almost everything we've talked about today with respect to the Bedouin, whether in the West Bank, whether in near Jerusalem, whether it's also in the Negev as well, shows that there's never been consultation, and there's never been an application of both the spirit and the law of the UN Declaration on the Rights of Indigenous Peoples by Israel in its treatment, of Palestinians in general, but of the Bedouin in particular. The removal of the community of Khams al-Baqa is one good example. That was opposed by the community. They were never consulted, except told to want to wind up leaving. So if we actually believe in the initiatives of equality and diversity in a society, we actually believe in the implantation of human rights in our relationships between government and peoples, and particularly specialized protection communities like Indigenous peoples, then it means working in order to be able to reach a consensus, in order to be able to have their consent to work on this. We're just at the very beginning of this long, slow, painful path in Canada, and Israel in its treatment has shown is not even on beginning to walk in that path, let alone identify it.
Thank you, Professor Lynk.
Yes,
please.
Can I also make a suggested answer for,
yes, please.
For this question? This is a discussion that is happening informally, I believe, here in discussions and different initiatives, also with the Bedouin communities. On the one hand, we believe that there are certainly benefits of using the indigenous people's framework, especially with the Bedouin communities, although we do use in our daily language the term indigenous for every Palestinian in Palestine, as opposed to the colonizing power and the colonizers who are transferring different segments of the Palestinian community from their homes and displacing them on a continuous basis. So one of the issues here is who is indigenous and who is not. This is a question that people discuss. However, there are additional issues when it comes to the indigeneity. One of them is the legal framework that we want to deal with. The indigenous peoples framework is not necessarily binding in this part of the of the world, and therefore, from a legal point of view, it might not be a helpful tool, although I might prove wrong. But to the best of my understanding, and we have a report that came up, maybe I will put the report's link in the chat later, and also as an answer to Netta's question. And by the way, the person who asked is a lawyer who represents Bedouins in Israeli courts on a continuous basis. So Netta, she herself is an expert actually on Bedouin issues. The question here is about the legal framework that we want to consider when we want to use international law as a tool for protection, or a protection that we seek, which we hope we will get. International humanitarian law, which is certainly applicable in the occupied Palestinian territory, is a strong framework. It's a framework that prohibits displacement, totally. There is no, there is a full prohibition of displacement, and there is a full prohibition of colonization in an occupied territory, of building settlements and transferring and occupying powers on civilians into the occupied territory as it would be described in international humanitarian law terms. So it's not about creating necessarily equality between the settler and the colonizer and the colonized. So I believe that the different frameworks are important, and therefore we would better stick to international humanitarian law and general international human rights law. For example, international criminal law is very important. The continuous systematic discrimination against Palestinians, the domination of the Palestinian community, including the Bedouin communities who are persecuted, as has been explained and described by all the speakers in this panel, who are persecuted and continuously ethnically cleansed and displaced, is one of the forms of the apartheid regime that exists in Palestine, Israel today. And that's another thing that I think we should build on. And I think it is probably more promising to get protection if we use these tools as we compare it to the indigenous people's tools. However, we understand also that the Palestinian Bedouins have a specific way of life that fit the general definitions of indigenous peoples, and that's certainly true. However, I am not sure that this framework is necessarily the best framework to use under the current circumstances. I actually additionally believe that when Palestine is free and liberated from this occupation and the apartheid regime, then it might become more important to make sure that this population, the Bedouin population, is certainly enjoying its full rights, also compared to other sectors of the community. But currently, we need the urgent protection of that international humanitarian law offers.
Thank you very much, Munir. Thank you, Netta, for your very interesting questions. There is another, there are some remarks and questions from the mission, a representative of the permanent mission of Iran to the UN in Geneva is thanking for the organization of this meeting, and is stressing the duty of the Human Rights Council to speak up for the human rights of all Palestinians. And he said that their mission appreciate the effort of the OHCHR and special procedures in this regard. His question is, what could be done more within the Human Rights Council to overcome this long protracted impunity and make this regime and this authority accountable for their crime against humanity and its war crimes? This is the statement and the question from the permanent mission of Iran. Another attendee is asking if there could be any change if the US doesn't change their policy on Palestine. Then most people, I think, are asking for the intervention. Maybe we, after the meeting, if you want to send me your intervention, who wants to share them publicly, then we could upload it on our website. Is there anyone that wants to make some comments on these questions and remarks? If not, and if there are no other,
I'm happy, Mikol, just to say maybe a couple of words. I think these last two questions speak to the same challenges that the international community, which in this particular context is embodied in the Human Rights Council, as well as individual members of the UN as as our global how shall I put this, as our global face of the international community. This is the $1 million question of anyone who works in international law and human rights in Palestine, and indeed in any context where we seek to see justice done in an equitable way to populations that for historical and political reasons have been treated by international law and those who define the parameters of international law as subaltern. Unfortunately, the reality from the 1940s onwards has been that the Palestinian people as a whole, and within the group of Palestinian people, the Bedouin, of course, are a prime example, and we're talking about them specifically today. The Palestinian people have been considered as subaltern in the international law inner and outer workings. And this is a sad reality that, for instance, the scholars who work within the critical framework of, say, third world approaches to international law and others have identified. So just to briefly reflect on the two final comments here, there aren't easy answers. There aren't easy answers, and this is why we need to carry on asking the difficult questions about, why is so little progress being made, despite some excellent intentions that we see in certain areas of the international community. This is why we want to make sure that issues such as this one remain firmly on the agenda of the Human Rights Council. This is why we extend the invitations to these sorts of events, not only to fellow academics and to people who work within the UN human rights system, and to people such as Nicole and her colleagues who work in the civil society wing of the human rights movement, but we extend our invitation to diplomats, of course, who have far greater power than any of us within the parameters of the United Nations and indeed the Human Rights Council. So this is a non-answer to your extremely important and difficult questions, but it's but I think it's important to remind ourselves that the UN is a community of states. So we want to make sure that states back human rights for Palestinian Bedouins, not just the UN bodies.
Yes, thank you very much. This is an important point you raised. Thank you, Alice.
Let me throw this in, if people will allow me. I'm presently in the process of completing my next report, my 11th report, to the UN General Assembly this autumn. And what I'm doing is looking at the actions of a number of significant states or organizations or institutions, and specifically the United States, the European Union, the World Bank, the Quartet, and the Office of the Special Coordinator for Middle East Peace. What I'm doing is coming up with 5 criteria by which to judge organizations and institutions and states. And let me just tell you what the 5 criteria that I'm working with are, because I think what this does is give a sharp knife to assessing whether we're moving forward towards the end of occupation or we're moving backwards towards the entrenchment and permanence of the occupation, the annexation. These 5 criteria are these. Number 1, the framework for fully ending the occupation must be a rights-based approach based on international law and human rights principles. Secondly, the end goal must be full Palestinian self-determination. Thirdly, we have to accept, which the world does not accept, certainly the Western world does not accept, that Israel is a bad faith occupier. Fourthly, because of the vast asymmetrical differences in power between Israel and the Palestinians, active international intervention is indispensable. This occupation will not end unless the international community acts with resolve and unity to force Israel to comply with its international legal obligations. And fifthly, the occupation must end not 10 years from now, not 30 years from now. It must end with all deliberate speed. When the United Nations Security Council passed its resolutions with respect to I guess you can call it the invasion of Iran or the invasion of Iraq or the occupation of Iraq, it said that the occupiers in 2003 must leave as soon as possible. It is international, it is at the corner of international law that an occupier stays in the occupied territory for as short a period of time as necessary in order to restore the institutions of the occupied power and of the occupied people and return the occupied territory in toto to them. These are the criteria that I'm going to be using to assessing, they said, the role of these 5 states, institutions, and organizations with respect to this, because it is, as I said in my comments, my formal comments to you, it is the issue of accountability that is lacking. That is the key to opening up the titanium cage that is this occupation.
Thank you very much, Professor Lynk. Looking forward to your report. There is one last question. Is for you, Professor Lynk. It mentioned I just read out the question to you. You have rightly mentioned the illegality and legitimacy of enforced displacement, ethnic cleansing, and illegal settlement as war crimes in your recent report to the 47th session of the Human Rights Council. Given that these crimes are violating jus cogens norms of international law, and we have erga omnes obligation of all states not to rendering aid or assistance in maintaining the situation, which is a grave violation of peremptory norms of international law, in your view, how violating states can be held to account as complicit to the grave violation of peremptory norms of international law?
Let me be brief, because I think I'm surrounded by a panel of expert lawyers and legal experts and legal academics here, so I'm sure they were able to chime in as well. But what we're seeing here, of which the occupation of Palestine is one of the most glaring examples of, is the limits of international law and the beginning of international politics. You know, the sad reality is that there's never been a conflict in the modern world where so much international law has been generated or has been clarified and expanded as the number of resolutions, the number of scholarly articles and books, and the number of statements has been made with respect to the rights of the Palestinian people. You think with respect to the rights of refugees, the prohibition against annexation, the prohibition against civilian settlements, and the right to self-determination. All of these have been greatly enlightened by all this work done on Palestine over the many years by legal and political scholars. Yet the gap is that so little of these the rights have ever trickled down to their intended beneficiaries, the Palestinians. So when we talk about international paralysis with respect to taking decisive international action on the question of Palestine and ending the occupation by Israel, we are talking about the limits of law, because we have very few international forums. We have no international legal forums which can actually compel an end to the occupation, unlike in a domestic court. And this really is left to the issues of politics, and in particular, the issue of the Security Council. The UN Human Rights Council, the UN General Assembly can issue a number of declarations, and they've added greatly to the legitimacy of the Palestinian right to self-determination. But what ultimately matters with respect to international politics and the application of international law is what goes on at the Security Council. The United States, since 1967, has issued 31 vetoes with respect to Israel's occupation of Palestine that were critical of the occupation. No other permanent member, no other of the 4 permanent members of the Security Council has ever vetoed a resolution critical of the Israeli occupation. That's where the logjam is in many ways. It is the United States, despite its proclamations for a 2-state solution, is the United States' strong alliance, military, diplomatic, and political, with the leadership of Israel that has enabled this occupation to last as long as it is. And I'm sure that all of us would agree. I'm not saying any secrets with respect to this, but I think it's a fact we have to wind up facing. If you read the memoirs of Kofi Annan, which he published in 2011, he talked about the inability of the Security Council to enact or enforce its own resolutions critical of the occupation. And he said, in particular, it had to do with the unhealthy possessiveness by the United States of its ownership of this particular issue.
Thank you, Professor Lynk. It's discouraging during the last aggression against Gaza, the Security Council was not even able at the beginning to release a joint press statement, not only resolution. That was very deceptioning. Just a clarification, the question I asked you, it was from the first secretary of the permanent mission of Iran to the UN. Because I didn't know, I just see names and it was not indicated. Now, does anyone else, Professor Rajagopal, Munir, Triestino, do you want to add something, Professor Rajagopal, or in conclusion?
So it's been very interesting just to, as I said, mostly I was here to listen, take in the views. I'll just say that I think we should just kind of maybe as someone who came in wearing the hat as a scholar who works on third world approaches to international law, more critical approaches. I came in as someone who perhaps had more of a critical sense of what was possible or not possible through international law and through mechanisms such as the UN Human Rights Council and others, than the normal, profile of people who come in to these kinds of positions. And maybe I could just say that, I haven't quite shed that baggage yet, although I've been in this position now for a year. And the one thing I would say is that the Human Rights Council offers a great deal of possibilities still for change. And I myself have seen in my own mandate where sometimes, persistent engagement with states can actually lead to specific, sort of changes on the ground. And I can cite examples, including some important impacts that I've had recently in the case of 2 countries, Netherlands and Bahamas, which did respond to concerns expressed, and things progress in a better direction. But I must say that whether it's the Human Rights Council or the International Criminal Court, they unfortunately suffer from the same power politics and paradoxes that have made the UN Security Council so dysfunctional with respect to the Israeli-Palestine issue. And I do think that because of these factors, it makes more sense to focus not only on these more traditional for accountability, but also to look at what's really going on in the name of colonization and settlement in Israel. What's really going on, I would come back to my remarks, is a form of racial capitalism. And there are many more actors involved than simply, for example, people belonging to the security establishment. Large corporations are involved, foreign companies are involved, there are finance flows that implicate leading global actors in our own countries. And they're all, part of the process of colonization. And if there are ways that can be found, for example, for tapping legal opportunities outside of international human rights law, international humanitarian law, and international criminal law, to perhaps looking at other areas of international law, including international investment law, trade law. International law is a larger phenomenon than simply human rights and humanitarian law and criminal law. And I hope that we retain that fully in our minds when we think about how to bring about accountability. Thank you. I think you're muted.
Thank you very much. Thank you very much. And I think the important point you just raised deserve an entire side event. This would be a very interesting focus for another discussion. So thank you very much for bringing this to the table. And if there are no other remarks,
Can I just add something very briefly, and just to say that I fully agree with what Professor Rajagopal was just saying, not to confine all efforts to traditional instruments of international law. Well, in particular, also, I didn't want, my intent was not just to say that we should just focus on the International Criminal Court, or just to say that there is this instrument at the moment, and to see the importance that this can have in the specific context, despite all the difficulties. But I know we are already beyond, the time. So just to say that in relation to the question raised, I think, by the Iran delegation, as members of this research project on the forcible displacement of Bedouin communities, we remain fully available, with the state's delegation, if anyone wants to discuss about this topic further, and to discuss and to see how to bring this discussion forward, and to discuss together how the Human Rights Council can address this very important issue, as we have seen today. So just this. Thank you very much.
Thank you, Triestino. So fortunately, we must conclude this meeting now. Once more, thank you very much to all distinguished panelists for their very important contribution to today's discussion, and for all their work in support of the Palestinian just cause for justice and freedom. Big thanks to Charlotte Cates, who is a colleague of mine from IADL, who worked very actively in the background to make this event possible. Thank you very much for your attention, and see you all soon. Bye-bye.
Thank you very much, Nicole.
Thank
Bye.
you.
Thank you.
Thank you,
Bye.
Nicole. Thank you,
Bye-bye.
everyone.
Thank you.
Thank you
for
very